because of my role in the governor's office, it doesn't really make sense for me to be part of the discussion in an active way, but I'm very happy to be here to just sort of introduce this great group and to say that, you know, I've spent the semester here, as I do many semesters, with students in the university talking about issues of law and education and how we solve problems that involve lawyers, educators, courts, and it's really so exciting, I think, to have an opportunity to have all of these great minds here talking about these incredible issues. As I always say to my students, I cannot keep up because every single day there's something in the paper that we have to discuss in class, and today's the final meeting of my course for the semester, so I dedicate this panel to all of my students. Should be the culmination of a whole semester of debating all of these issues. And to the rest of you, I think you're in for a real treat.
This panel will focus on the role courts should play in public law litigation involving education and other social policy matters. This issue is commonly discussed in terms of judicial activism when applied to the United States Supreme Court, and it involves a fundamental tension between, on the one hand, the limits on judicial authority required under our system of separation of powers, which vests basic policymaking power, as you know, in the legislatures and executive branches. On the other hand, the constitutional tradition of judicial review, which calls upon the courts to enforce individual rights at times by invalidating legislative and executive actions. This tension is present in the Constitution itself. On the one hand, we're all familiar with principles that say the majority rules, and that is certainly the default position of government in our society. At the same time, think of this. We would not need a constitution if we always trusted the legislatures, always trusted the executive to make the right decisions. The very existence of a constitution presupposes the awareness and the need that there will be occasions where the political majorities may need some help from other branches of government. So, the question we're going to discuss today is, are there principled ways of determining when judicial intervention in educational policymaking is proper and when it's not? And if such distinctions can be drawn, on which side of the line do the issues we've been discussing today, tenure, teacher dismissal, seniority, layoff statutes, at issue in Vergara, Davids, and Wright, where can we draw the lines and why? How do such cases compare with other educational issues, such as school desegregation and school finance reform, in which courts, in some cases federal, in other cases state, have taken active roles? So these are the main issues our panelists will explore. And we're fortunate to have an impressive range of viewpoints represented. One of our panelists will argue that the courts should not intervene in cases like Vergara, Davids, and Wright, or in school desegregation or school finance cases. At the other end of the spectrum, we have a panelist who will argue that courts should be willing and are competent to intervene in all these kinds of cases. And a third panelist will argue that judicial intervention is appropriate in some situations, but not all. We had wanted to convey the range of thinking on each of the issues we discussed. Our panel has three distinguished participants. You have their bios in your materials, so my introductions of them will be brief. In the order in which they'll speak, they are, to your right, to my far left, Joshua Dunn, an associate professor of political science at the University of Colorado in Colorado Springs, where he teaches courses on American political institutions, constitutional law, and political theory. His research has primarily addressed questions connected to judicial policymaking and education litigation, including desegregation, school finance, school choice, school discipline, and most recently, the very issues we've been talking about today. Welcome. To his right, to my left, is Michael Rebell, known well to all of us here, professor of law and educational practice on the faculties of Teachers College and Columbia Law School, and also the director of the extremely important and effective Campaign for Educational Equity here at Teachers College. The author of influential studies of the role of courts in school finance and educational adequacy cases. And after what you said earlier, Professor Hanashek, I will add persuasive as well. He also, as many of you know, was instrumental in winning a major lawsuit in which New York's highest court found that the state of New York had failed in its obligations to provide a sound basic education for students in New York City and elsewhere in the state. To my immediate left is Kevin Wellner, professor of Educational Foundations Policy and Practice at the University of Colorado Boulder School of Education. He's a specialist in education policy and the law, and is also the director, and I hope all of you are aware of this and read this research as well, of the National Education Policy Center, NEPC, which is housed at CU Boulder. It's hard for me to think of an issue on which Professor Wellner has not written influential articles, but his topics include tracking tuition tax credit vouchers and the change process associated with equity-minded reform efforts. As with the other panels, I have asked each panelist to speak for 10 or 12 minutes. And after that, each of them will have 3 minutes to respond to comments from the other speakers. I also have some questions to pose before we turn to the audience for questions. But after the last two panels, I'm inclined to encourage the presenters themselves to see what they can do to sharpen their agreements and disagreements, to see, what is the domain in which we actually agree here, and where are the disagreements? So with no further ado, Professor Dunn.
Thank you. It's a real privilege to be here. I do think that the Vergara decision is extremely important, so to be a participant in this very important conference really is an honor. I should go ahead and say that I was a little alarmed to hear Rick say that he'd been persuaded by Michael, but maybe Michael's moving more in my direction, so we could arrange a trade at some point. I don't know what your head-to-head record is, but or maybe after this you'll come back. I also would like to say that with my comments today, I will be arguing against my own interests. I would say that I'm very sympathetic to the policy claims of the plaintiffs in Vergara and here in New York. But for various reasons, I think that the courts are not the appropriate venue for debating these issues. And I'll try to make that clear. Just so you know, I've benefited from policies that have allowed greater flexibility with hiring and firing decisions in public education. My own kids attend a charter school where I can see the benefits of that. It's not appropriate for everyone, but it works for us, and so I appreciate that. And I would like to see others have the same opportunity that my children have had because of that. To get started, I'll be optimistic. I'm going to read a quote from a recent book by Peter Schuck, a great law school professor at Yale. He's written a lot on the courts and policymaking, but he also just wrote a book, Why Government Fails So Often and How It Can Do Better. I'll just go ahead and tell you, if you haven't read it, there's a lot of failure in the book, an awful lot of failure, and not much on how it can do better. So, but here's what he said. He said, policymakers can have at best a severely limited knowledge of the opaque, complex social world that they seek to change and meager tools for changing it. he was talking about all policymakers there. I think that quote applies in particular to courts, that many of the problems that he identifies with trying to create social change afflict courts more than other institutions. So I was glad that Michael brought that up. I'm certain that we'll have some disagreements about this, but I do prefer to focus more on comparative institutional advantages, or in this case, perhaps disadvantages, than just on the principled arguments about whether or not it violates the Constitution. I think that, by and large, we're all have strong intuitions about what constitutions should say, and so we tend to be confirmatory readers of constitutions rather than exploratory readers of them. So by focusing on the ability of courts rather than on these deeper constitutional questions, you can get perhaps a more honest view of what you actually think courts can really do. To continue the optimism, I'm going to read a quote from at the time, this is from 2001, a little-known state senator from Illinois when he's being interviewed by public radio in Chicago, and it deals directly with the power of courts or the capacity of courts to create social change. Here's the quote. He says, just look at very rare examples during the desegregation era. The court was willing to, for example, order changes that cost money to a local school district. The court was very uncomfortable with it. It was very hard to manage. It was hard to figure out. You start getting into all sorts of separation of powers issues in terms of the court monitoring or engaging in a process that essentially is administrative and takes a lot of time. The court's just not very good at it, and politically it's very hard to legitimize opinions from the court in that regard. So I think that although you can craft theoretical justifications for it legally, I think as a practical matter, our institutions, the courts, are poorly equipped to do it. That, of course, is President Obama. That interview gained some notoriety when it was broadcast over the Drudge Report, accusing him of being a socialist or something like that. But if you actually listen to it, he had a very careful commentary on the power of courts, the ability of courts, and that was really his central question. He was repeating many of the arguments of his colleague at the University of Chicago Law School, Gerald Rosenberg, from his book, The Hollow Hope. And I think there are good reasons to agree with President Obama on the capacity of courts. I will, before getting into some of my criticism of the court's capacity, I will go ahead and mention why, if you're in my position, you could perhaps craft an argument for not being as skeptical about the courts in Vergara and here in the New York litigation. I think the main reason you could come up with an argument, this one I'll explain why I don't agree with it, but I do think that the evidence that teachers matter is far more robust and more persuasive than the evidence on the effects of money on student outcomes. I think that's just the research is just far superior and far more persuasive. So I could come into this and say, well, this evidence is much more persuasive, so I'm willing to relax my opposition to the capacity of courts to create social change and say that Vergara and these New York cases aren't going to be a problem. But that's not going to be the case. That's not going to be the case. I actually think that in many regards, the evidence on teacher effectiveness is more problematic. Parts of or rather the missing evidence on teacher evidence is more problematic than the evidence that we do have showing how much they actually do matter. A couple other comments, though. I want to say a little bit about Judge Troy's opinion. I was glad it was brought up in some of the shortness of it, the brevity. I know Rick thinks that wouldn't have gotten as much attention. That's probably true, but my impression upon reading it was, I've got the press release now, I'm waiting for the opinion, the ruling, and it never came. It never came, and I think that actually does matter. I think it does matter, and I think for that reason, because he didn't really articulate a good legal rationale for his opinion, it increases the likelihood of it being overturned on appeal. I wasn't surprised by the decision. Everything I was hearing indicated that he was leaning in that direction, but I would be very surprised if it's upheld on appeal or if it's just rewritten in a way to really change it completely once it's all said and done. The first thing I'll say, though, is that he did say that he was not judging the wisdom of the statutes. I think the charitable way of describing that is unpersuasive. He obviously was passing judgment on the wisdom of the statutes. Another way of putting that is he was saying, I'm not going to engage in policymaking. I'm going to say that these statutes are unconstitutional, then I'll leave it to the legislature to come up with constitutional statutes. But of course, there always has to be a constitutional standard to determine whether or not the legislature has come up with an appropriate remedy. Rights demand remedies. If you can't show a remedy, more than likely you don't have a right. I think, is a real problem for his opinion. There also was a lot of slippage between quality and equality in the opinion. I was never exactly sure what the foundation for his ultimate judgment was. Was this because it was a violation of equal protection, or because students have a right to a certain kind of teacher? I think that ultimately you have to say that it's grounded on the idea that students have a right to a particular quality of teacher, because equally bad teachers wouldn't violate equal protection. Right? And that's obviously not what he was trying to argue for. So now to the arguments for why courts aren't terribly effective. I'm going to give four arguments. These are compressed. In the literature on judicial policymaking, there's lots of reasons that are given for why courts aren't terribly effective at policymaking. I would say today, most people agree courts aren't very effective. The prominent position that defends judicial policymaking today is called the New Legal Process School, and that basically admits that courts aren't very good, but then says, well, sometimes they aren't as bad as other institutions, which isn't a very strong defense. So most people accept that courts have limitations, and these are I think some of the commonly accepted ones. And some of these have already been mentioned, so some of the other panelists have saved some time for me. The first is inadequate information. The information that courts receive is problematic. The adversarial nature of the legal process contributes to the poor quality of information that they receive. The nature of judges themselves makes it difficult for them to actually understand sometimes very specialized information. But in this case, in the Vergara case, here's what I think is the problem. Since I think the decision is grounded on the argument that students are entitled to a particular quality of teachers. They have to have an effective teacher of some sort. And I do think the evidence showing that effective teachers make a huge difference in students, that's all very good. But if that's the right, you have a right to a particular quality of teacher, the remedy has to be a particular quality of teacher, an effective teacher. And my sense of the literature on this is that we don't know where effective teachers come from. We're here at Columbia Teachers College. I'm certain there's some people who can tell me about this, but my sense of the literature is we know that effective teachers make a huge difference, but we don't know where they come from or really how they became effective. We can have policies which will help encourage them to be more effective, but where do these people come from? And as far as I understand, there's just no real evidence on that. But ultimately, that's what someone's going to say. Someone's going to come into court and say, I'm entitled to a particular quality of teacher. My fourth grade teacher isn't up to this measure, and so give me a teacher who is. Right? So that's the first problem, inadequate information. Second, courts artificially isolate problems that in the real world are merged. And this is where I do think legislatures and executive agencies and the executive branches have a comparative advantage over courts. Courts can only address the legal issue that's before them. But we know that education is a huge, complex social policy and area where many things affect it, but the only thing that courts can address is education policy. And it becomes, also as Rick said, a very blunt instrument. We'll use the one thing that we can. You see this, we don't have any other way of trying to affect it, so we're going to push really hard on this. So in the case of Vergara, you have this question. The judge concluded that children in poor and minority schools have more, grossly unqualified teachers? Then the question is, well, why? And that's something that the opinion doesn't really explain. And that's a problem that's connected to all sorts of other issues that in this case, the judge just looks at completely in isolation. The final two problems that I have, that I want to mention with the courts and public judicial policymaking would be unintended consequences. Clairvoyance is hard. It's particularly hard for courts. The courts are good at fact-finding, but they find it very difficult to make predictions about the future, particularly, once again, in comparison, I think, to legislatures. And in the Vergara case, we don't know what the policy consequences will be. We have no idea how the legislature will respond, but I do suspect there will be some unfortunate legal consequences from the case. One is more litigation. that will be one obvious consequence, and we don't know where that will go. Litigation is costly and uncertain. I do think there will be increased challenges to individual teachers. And I also I'm interested to hear Michael's comments on this, but I think with some of these decisions, if they ultimately end up being upheld, school finance litigation could build off of them. I'm not certain about that, but I would be surprised if you weren't thinking about that. And I would hazard a guess that the people who are leading these litigation efforts aren't excited about the idea of Michael Rebell knocking on their door in a few years. And then finally, I would say insufficient power. Courts just simply have insufficient power to accomplish the things that they want to accomplish. This would be the constrained court argument that you find from Gerald Rosenberg. I think the obvious solution to the problem, as it's been, as Judge Troy outlined it, is to reassign teachers. If poor minority schools have higher percentages of grossly ineffective teachers, then reassign teachers. That's not going to happen. That is not going to happen. The court simply doesn't have the power to do that. Or maybe make administrators evaluate effectively, or evaluate at all. Are they really going to get involved in that? I think it's highly unlikely that they're going to do that. So, in conclusion, I can see the temptation of going to the courts. Courts can do things. After all, an opinion is something. We are here today talking because of a decision issued in California. That's something. But to really conclude, I think we should consider the words of the great legal scholar John Wooden: never mistake activity for achievement. In this case, we have an opinion, there's been action, but I'm not certain what achievement it'll lead to.
Thank you very much. Professor Rebell.
Okay, thank you. Well, I've got quite a challenge here. Rick Hanushik said a little while ago, for those of you who aren't here, that he now agrees with the conclusion of my 2009 book, Courts and Kids, that courts can play a very effective, helpful role in litigation. And that's astounding to me because at the same year, he wrote a book that said the courts essentially have no business getting involved in these things for many of the reasons that Josh just outlined. I don't know that I take that as having convinced Rick as much as, you know, when the context changes and the issues change, maybe you see the role of the courts in a slightly different way. So I'm not going to totally switch my perspective. I do think courts can be very effective. I think court intervention is very important in education finance cases and desegregation cases, in a number of other areas. But I don't think that this challenge to teacher tenure laws, teacher dismissal laws, is an appropriate area for the courts to get involved in. And without spelling out my personal views on the issues, I will say that I personally do see some problems with the 3020A procedure in New York State. I think the burden of proof is much too heavy, even though there have been improvements over the years, as Rich Casagrande said. I think we've got a long way to go there. But to raise this kind of issue to a constitutional level and say this is a violation of either equal protection rights or sound basic education rights, when the proof of what's going on here is so scanty as it was in the Vergara case, or at least the causation links between whatever deficiencies there were in those particular statutes and the ultimate question of whether kids are getting an effective teacher, leads me to believe that this is not an appropriate area for judicial policymaking. So to put this in the perspective in which I see it, and which I did emphasize in the 2009 book, I hope, Rick, you didn't just read the concluding pages, but you read the discussion that led to it. Courts are very sensitive to separation of powers agreements. Sometimes for this reason, they won't get involved in major issues, even desegregation in school finance. About 2/3 of the courts, of the state courts in this country, have gotten involved in trying to reform the systems for financing public education because they were convinced by heavy evidence at trials that these systems were very unfair and were not providing sufficient resources to give kids an adequate education. But 1/3 of the courts, basically for separation of powers agreements, didn't even want to hear the evidence. They just said, along the lines of what Josh was saying, that courts have no business getting involved in these things. I haven't changed my position on education finance. I think it's important for courts to get involved. I think they have a responsibility under judicial review. And the reason is that these are judicially manageable areas. We have a doctrine in the law known as political questions, and courts that really want to avoid getting involved in some of these difficult policy issues. And usually when they're coming to the courts, they're very controversial, they're very difficult, as this one is. But they'll say this is a political question, should go to the legislature. Courts don't have the capacity to do it. If we get involved, there are no standards we can use to figure out how we can improve the situation. There's no way we can come up with a remedy. Well, in the education finance area, there were very clear, manageable judicial standards. And many of those standards were created by the legislatures themselves when they passed standards, content standards, accountability standards, graduation standards. And it was very simple for the courts to say, look, New York State, most other states have now defined what it is that you need to learn, what it is you need to do in terms of passing 5 Regents exams and all in order to graduate. So the standards are there, and the question that's being posed by the plaintiffs in this case is, have students been given a fair opportunity? Do they have a reasonable set of resources to be able to have a fair shot at meeting these very clear standards? So the remedy direction was relatively clear. We get into a situation like Vergara. As Josh has pointed out, yes, there are difficulties with these dismissal statutes, with these tenure statutes, but exactly how to solve those problems, nobody knows. The pros and cons of tenure we heard debated very sharply this afternoon, and there are very intricate policy decisions going on there. Very difficult for courts to intervene there. And part of the really heart of the issue, I think, is that we don't know if the tenure statutes are the prime cause, if there's a strong enough causal link between whatever problems exist there and the ultimate question of why we don't have effective teachers. So for the courts to get involved in this is really digging into the weeds of education policy. And that's where I think we can make some very principled distinctions, as Jay put it in his introduction. Courts don't have the capacity, for some of the reasons that Josh said, to be roaming policymakers, to be intervening in all kinds of areas where somebody who brings a case to court thinks that there's a problem and somebody should do something about it. They do have to reserve their ammunition, they do have to reserve their resources for questions that rise to real constitutional levels. So my position is education finance does rise to that kind of a level, and the kinds of very nitty-gritty, detailed policy issues that we have at issue in Vergara and Wright and Davids simply do not rise to that level and should not appropriately be in the court domain. Now, I do want to say something about how courts should operate in the areas where they appropriately can manage both a well-conceived liability decision about whether a constitutional right is at stake here, and the ultimate remedy if they determine that there is a right. And that's a method that has to take into account 2 things. One is what I call comparative institutional perspectives. I mentioned earlier on social science evidence. In some situations, courts are better decision makers on interpreting social science than legislatures or courts. They have very extensive mechanisms in terms of discovery, in terms of the advantages of the adversarial system. Cross-examination, many people have said, is the most effective vehicle for winnowing out the truth that human beings have ever devised. So there are negative aspects to this, but there are many situations where judicial fact-finding is really important and is really essential. So courts do have strengths of this type. There are other areas where you get into remedy issues that may have far-reaching consequences that are not easy to determine, as just indicated, where the courts probably are relatively poor policymakers. One of the comparative advantages that courts clearly do have is that they have to justify their decisions in written opinions that have to conform to certain established professional standards. And that means that when they do get into questions of constitutional rights that are of sufficient magnitude, they have to clearly explain what their rationale is, how it relates to the constitutional law at issue, and how the evidence that's been presented at the court creates the kind of causal link we were talking about earlier. I agree with Josh that certainly at this level, the opinion in the Vergara case doesn't measure up to the usual professional standards. It may be that if an appellate court wants to uphold a decision, they will reach back into the evidence and they will find stronger links. But this one is very unconvincing. It's a poor judicial decision. Most decisions in major constitutional cases are a lot more weighty than this. But that has to do very much with the liability aspect. Once a court's decided to get involved in the matter, question is, how do they shape a remedy? And I talk about the importance of judicially manageable standards. But the other aspect of this is a sensitivity to separation of powers. Even if a court's taken jurisdiction, they do have to be respectful of the policy-making prerogatives of the other branches and determine where those branches are more effective than they can be, but at the same time, doing it in a way that upholds a constitutional right. For me, one of the approaches that I think has proved effective over time is the one that the federal court in the Fifth Circuit came up with in the Castaneda case. That was a bilingual education case decided in the 1980s. And the court said at a remedy stage, basically, we go through a threefold process. And the first is, we say to the state, there's a problem here. In that case, it was a problem about the provision of bilingual services to kids. And they said, you come up with the solution. You come up with what you think is the best bilingual policy. And it could be bilingual education, it could be English immersion, it could be a whole host of different ways of treating bilingual. Not the court's business to get into that. That's up to the legislature. But the second stage is, once you've decided on a reasonable policy approach, then you have to carry it out. You have to implement it well. You have to adequately finance it. And that we're going to hold you responsible for. And third, after you've chosen your policy mechanism, you've chosen the way to implement it, you've got to show results. I mean, these kids have to be able to learn to function in an English-speaking environment. So that's the court being the overall supervisor, not deciding the details of the policy, not digging into the weeds the way the court has done so far in Vergara. And for me, that's how the court should operate. Now, I don't want to say that sound basic education, our constitutional standard in New York State, is limited only to education finance cases. So far, that's what the court has said. Those of you who were here earlier heard me ask a question to the plaintiff lawyer in the Wright case and say, what precedents, what arguments do you have for extending sound basic education beyond the area of funding, because it's pretty clear that the New York Court of Appeals is going to be very cautious about doing that. For me personally, and I'll pick up Josh's point about what resonates in what we've been talking about today for future litigations that I would think is appropriate, I think there may be a constitutional right in terms of sound basic education for students to have an effective teacher. I think we have to think a lot more about that. I think we have to develop the concept a lot more. But if there is a right to an effective teacher, it goes well beyond tenure, dismissal statutes. It goes to the issues of how do you deal with teacher retention, how do you deal with dysfunctional leadership that Susan Moore Johnson was talking about, how do you deal with attracting people, how do you deal with salaries that Rick agrees should be higher. So it's a lot larger scale issue. And we have to think through if there are manageable standards, whether the court intervention can be really helpful there. That's why I posed that question to Rich Casagrande, whether he thought there was a right to an effective teacher. And I think that is a constitutional issue that many of us are going to be thinking about, certainly in New York over the next couple of years. And I hope that will be the ultimate legacy of Vergara. My prediction, I agree with Josh on this, is that the California Supreme Court will reverse Vergara. What that will do to the precedents in the two cases we're talking about here, we'll have to watch as time develops. It is a different constitutional theory in New York, but I do think that what will come out of this is a lot more focus on what I think may be the true constitutional right, a right to an effective teacher, and not the weeds of whether it's the dismissal statutes or a little piece of it like that. Thank you.
Professor Rebel. Professor Wellner.
Thank you. I want to discuss the silver lining, if I think, and I also agree that it's a very poor decision in terms of what Judge Troy wrote and in terms of the evidence and causal relationships. But that's not what I want to focus on. I want to focus on, if it is upheld, if we do have an appellate decision that uses similar reasoning, what might that mean in terms of what I would consider to be silver linings? So while I think the Vergara decision itself is a stretch, contorting both the law and the facts and reaching a misguided result, the direction taken by Judge Troy in Vergara is one that I think has a silver lining. So what I want to do is I want to start this talk in science geek mode. So bear with me while I take you back to your high school chemistry and the idea of activation energy. You can't fry an egg without turning on the stove, and this rock won't get over this hill to a lower energy state unless you first add the activation energy to get it over the hill. So, as I will explain, I think what Judge Troy did is to shift from A to B in this diagram to lower the activation state. To lower the activation energy needed to reach a successful education rights litigation result. But this analogy is useful for me for a different purpose as well. And take a look at C. C is the ending energy state. Now, sometimes some reactions, this is an exothermic reaction, the ending energy state is lower. Sometimes you could actually have an endothermic reaction where the ending energy state is higher. A nuclear reaction is highly exothermic, and the reason why we don't have nuclear reactions going on all around us is that it takes a lot of activation energy to get there. So in terms of education rights litigation, I think of C as the seriousness of the constitutional violation. Oop. So currently, only major violations of education rights have any real potential for success in the courts. And even then, it's pretty dicey. And this is because of the very high activation energy, the high burden of evidentiary proof placed on plaintiffs that is very difficult to meet. Mike, I thought, Mike, you were walking out on me. Let me go to the next. Damn. Okay. It's like it's like a practical joke. Okay. But using the plaintiff-friendly approach that Judge Troy applied in Vergara, we have two new possibilities. Of course, given the evidentiary and causal issues, I think of the Vergara case as being in the third quadrant there, at best. But I think that, in other words, I think that in terms of Vergara, if there was a constitutional violation, it was very minor. But let me see if I could. There we go. But using this chemistry analogy, I think of Vergara as it it had a very low or plaintiff-friendly activation energy, but also, I think, a very low C, the difference between the education rights before and after the court's remedy, to the extent we could figure out what the court's remedy is. In fact, the Vergara reaction might actually be endothermic, I think, where the student's educational opportunities are harmed by the court's decision. So to some extent, it's always going to rely on the subjectivities of the judge that are going to come into play. But for that reason, I would argue that Judge Troy applied his legal standard in a way that was actually way too plaintiff-friendly, which is not something you hear me say a lot. And that the court's evidentiary findings and its treatment of the causation issue that you've been hearing about, and Susan Moore Johnson's discussion of the evidence, I think applies here, it was just way too underdemanding. The court was very, very credulous of all the evidence put forward by the plaintiff and didn't consider all the other evidence that Dr. Johnson was talking about. So that's, I would argue that to some extent we should be thinking about Judge Troy's decision and the legal standard, which I'm going to talk about in a second, as a positive development, but also understand that we need to have, as part of this sort of approach, if it's to be successful, there needs to be a larger C. In other words, there has to be a strong enough evidence to see the difference, the benefit to the plaintiffs before and after. So what I want to stress is that my criticism of Judge Troy is in his application of the legal standard as opposed to and separate from my embrace of his legal standard itself, to the extent I could figure out what that legal standard is. So my focus here is largely on the fourth quadrant. And the fourth quadrant here is, what I'm saying is that it's true that by lowering the standard for review of laws and policies that may violate students' education rights, we may end up with courts striking down laws that are at worst marginal violations. That's sort of the quadrant 3 there. But we're also putting courts in a much better position to address major violations, quadrant 4. Took me a while to come up with this slide. So as Michael and Josh have explained, Judge Troy did engage in judicial activism. I don't think there's any question about that, in the sense that he did not defer to the political branches of government, and in fact, I think he overreached to strike down a set of laws. But a counter-majoritarian role is clearly necessary at some point, right? Without the courts, legal protections would have no meaning. Those with power, including legislatures and governors, would be able to flaunt the law with impunity. So some of the most repressive societies on earth have lovely language about human rights in their constitutions. They just don't have a judiciary that's able or willing to give them any meaning. So our own Equal Protection Clause, in fact, was of little use for its intended beneficiaries for 86 years until the US Supreme Court applied it in a meaningful way in Brown. So ideally, we would never need a court to invalidate a law because legislators would not pass unconstitutional laws and governors would not sign unconstitutional laws. But when such laws are passed and signed, courts should engage. So the question then becomes, are judges well suited to make education policy? And the only fair, honest answer there is no. But are legislators well suited to enforce constitutional provisions that protect education rights? And I think the only fair answer is no. So what we have is a situation where we have a system of trade-offs. And if we care enough about enforcing these provisions, then we must be willing to accept the drawbacks of judges making decisions that complicate education policy. The alternative, I would argue, is what we now have, which is a system that is largely ineffective at interrupting the cycle of intergenerational poverty linked to our persistent opportunity gaps. In other words, I completely agree with all the criticisms of courts and their limitations, and I would ask you to think back about the list of problems that you've heard about courts and ask yourself how many of those apply to Congress and to your state legislatures. So let's take another look at what Judge Troy did. So if others have explained, Judge Troy found 5 laws unconstitutional. More to the point, he struck down the seniority-based layoff policy. Did I get that right, Susan? Okay. And a policy that provided a 2-year review period for the tenure decisions and for strong due process protections before dismissal. So technically, though, what the court found is that the state failed to show a compelling interest to justify policies that the court decided were causing employment of several thousand grossly ineffective teachers scattered throughout California, and that this undermined the quality of education for students in those classrooms. Now, in this quote from the Vergara decision, I highlighted the real and appreciable impact language, which I'm going to return to here. So, the primary precedent for Judge Troy's decision is a 1992 decision of the California Supreme Court, where the court found that students' education rights were violated when a school district ran out of money and ended the spring semester 6 weeks early. The court held that the state, not the school district, but the state of California had the ultimate constitutional duty to ensure, to step in to ensure that students receive, and here I'm quoting, basic equality of educational opportunity. The court stressed that the early closure of the schools would result in a loss of almost 1/5 of the standard school term and would therefore, quote, cause an extreme and unprecedented disparity in educational services and progress, thus resulting in an extensive educational disruption. So the generally understood holding from the California Supreme Court was that, and this is a quote from the Butt decision, unless the actual quality of the district program viewed as a whole falls fundamentally below prevailing statewide standards, no constitutional violation occurs. That's a pretty tough standard, even by California standards. So Judge Troy never applied or even addressed or mentioned these elements of the key precedent. There was no viewed as a whole, there was no fundamentally below, there was no extreme and unprecedented disparity, just a finding of a real and appreciable impact and then a shift of the burden of proof to the state to prove that the 5 statutes were necessary to serve a compelling state interest. So to be clear, California jurisprudence in this area, based on T.K. Butt and before that on the Serrano v. Priest decision, when I practiced this earlier, it was much shorter. On the Serrano v. Priest school finance case was already one of the most plaintiff-friendly in the nation. But Judge Troy then transformed the legal standard into one that is truly remarkable in terms of its low activation energy. And we could argue whether that's a good or bad thing, but we should agree that it's transformative. So the Vergara plaintiffs pointed out that teacher quality, which is important to students' opportunities to learn, is unfairly distributed among schools and among students. And we can probably all agree up to that point. But everything after that required Judge Troy to accept the plaintiff's dubious version of legal rules, causal hunches, and highly disputed research. Now, I have lots of slides on that topic that I had to cut out because of these time restrictions, but the key point is that Judge Troy's decision and legal reasoning, if they are upheld on appeal, will put in place beneficial precedent that will, I think, breathe new life into education rights litigation. And yes, some of the Quadrant 3 decisions will leave us scratching our heads. But given the train wreck of a political system that we now have, I think we should be willing to accept the bad with the good of a system that increases the scope of judicial review. Political decisions are designed to further the ideas and interests of the political majority, which works wonderfully in most contexts. But it does not work wonderfully in distributing educational opportunities. Judicial review, on the other hand, is designed in such a way as to potentially protect the rights of the political minorities. It is a decidedly imperfect way to do that, but it is one of the few tools actually available. And this is the last slide. So that's the silver lining. I chose this slide as a reminder that reaching an activation energy isn't necessarily a good thing. But in the face of politics generating a very unfair system resulting in enormous opportunity gaps, Judge Troy and the backing group Students Matter have offered us a light out of the education rights litigation darkness. The legal standards that Judge Troy has set forth in the Vergara decision provides a sort of check on political power that would be necessary if we were to see any real progress in closing those opportunity gaps and therefore closing the nation's appalling achievement gaps. Thank you.
I think one thing where we have an area of disagreement is not over whether rights should be enforced, but what the proper method of protecting rights in our constitutional system is. I don't find a lot of evidence that the people, for instance, who wrote the Constitution and then people who wrote state constitutions thought that the primary way we would protect rights would be by writing them down and then handing them off to judges to enforce. That's a role, that's one part of it, but primarily it comes through a institutional design. This is what you find in Federalist 10, Madison's explanation, and Federalist 51 of how rights are best protected. And so the best way then to protect rights is to make certain that the political system and certain things like separation of powers are protected. And so then if courts actually violate separation of powers and intrude improperly into the legislative branch, it could actually be a threat to rights. So that's one thought. I'm not certain I accept the idea that if you don't think judges should get involved, then it's open season on students' rights. A second, and this is a second comment and question for Michael, is I would like to hear more about your thoughts on the connection between school finance litigation and Vergara and the other litigation, which is undoubtedly going to come. Because in the one case that wasn't mentioned was Serrano versus Priest. Yeah. So, or in my reading, that was really the foundation of the decision. Without Serrano, you don't have Vergara. So is it possible that every state that has had a successful school finance case, either equity or adequacy, is now primed for litigation like Vergara? And then what would you recommend to be done about that?
Well, it may be that every state's going to be primed for litigation like Vergara, because I understand that some of the supporters of this direction have deep pockets and may have an interest in promoting litigation everywhere. Whether it'll be successful is another question. And I think a big factor there is going to be what the California Supreme Court ultimately does. If, as all three of us have predicted, they reverse this decision, then this may be a small footnote in somebody's doctoral dissertation a few years from now about how one judge opened up this huge possibility that got slammed shut. If it's upheld by California, it may have wide-ranging implications, as Kevin is pointing out. I would emphasize, though, the fact that the Serrano decision, which was the education finance decision in California that went back to '73, is not the constitutional basis that most courts that have decided education finance and adequacy cases in more modern times have chosen. California is one of, I think, only 2 states that has held that poverty is a basis for strict scrutiny, and that is implicit in Vergara. It's a very strong equal protection standard in California. And as both of the lawyers who were on our first panel today agreed, the Vergara approach, the Wright-Davids approach, doesn't work in New York under equal protection. We have a very different legal structure. Education is not a fundamental right under the Equal Protection Clause in New York. We have sound basic education, very different constitutional perspective, which does not apply in California. So each state is going to be different, and where it can go, one can only imagine, and it'll depend, as I say, on the ultimate decision in California. But the point that I'd like to emphasize in this short amount of time I have now is really in response to Professor Wellner's perspective here. And although I'm one who does champion equal educational opportunity and would like to see reform in many, many areas, I do think that judicial capacity is a rare and a limited resource and needs to be used well. For a court to do a good job is very time intensive, it's very resource intensive. In our CFE case, the chief judge in an extraordinary way freed up our judge for 7 months from all other cases, all other responsibilities, so that he could dig into detail on every aspect of funding in the New York City system, in the state education finance system, and that's what it took to do the job right. Appeals courts took hours and hours of arguments. We had 3 times the length of the argument of any other case that year. And putting that time and effort into it, I personally think the New York courts did a great job. But the point is, they can't do that with every issue that comes up, with every claim of denial of equal opportunity. And instead of spreading themselves thin and taking all the political flack that would come with the territory, I think we have to husband this valuable resource for those areas where it's really important, it can be done right, and it can make a difference. And as I said earlier, the tenure dismissal areas in Vergara don't rise to that level in my mind. The larger question of an effective teacher may, but it's going to take a lot more thought to figure out exactly what that right would mean, how it should be shaped, and how the courts might get involved. And Judge True's decision gives us very few guidelines along that path.
Should I try to defend my position here?
If you'd like.
Okay. Actually, one of the things that Jay, is this on? One of the things that Jay asked me to do, I don't know if I can get back to my slides or not. Oh, probably this way. Yeah. I don't know what happened back. Is it? Okay. See, now I'm actually trying to get through quickly. One of the things, whoa, there it is, that you asked me to do was to think about my post-Vergara wish list. In other words, what other, if this standard of real and appreciable impact is put in place, what other areas might be litigated? What other areas that I think of as resulting in denials of educational opportunity or creating opportunity gaps might we then litigate? So I came up with this brief list. I'm sure we could add more to it. And obviously, to some extent, I'm playing court jester here. I mean, I recognize exactly what Michael is saying in terms of the transformative nature if we move to this real and appreciable impact standard. And I think I'm doing that in part to point out how absurd the Vergara decision is. At the same time, part of me really looks at the current situation and finds it so intolerable that I think this sort of, what you might want to think of as creative destruction of the system, it is worthwhile. You know, it's for those people, and I'm glad Mona Davids, I don't know if she's still, yeah. I'm glad that we had that voice here, because it really is important to take us out of our comfort zone and recognize that there are kids who are at the very, very wrong end of nasty opportunity gaps. And to some extent it's about teacher quality, to some extent it's about all these other things. And you know, the political process during my lifetime and in my reading of times before my lifetime has not served children well who are living in poverty, and for the most part people in communities of color. So I think that while I acknowledge every single point that was just made, I still think that this is something that we really can see a silver lining in. And you know, maybe if we stopped all the prosecutions of nonviolent drug offenses and things like that, maybe we could open up some court space to address some of these issues. So.
I'd like to follow up on that, if I might. Tell me if I'm mischaracterizing, but I feel a little bit like Will Rogers. I never met a man I didn't like. Is there a serious equity issue that you wouldn't encourage courts to weigh in on once the other branches have shown their inability to do what needs to be done?
So that's a good question.
And I have a second question, maybe for the two of you. and that is, what does that imply for the need for competence on the part of lawyers and the courts? And Professor Dunn, you started out by quoting Peter Schuck, and I remember something he wrote once. He said, where lawyers and law professors are concerned, social science research corrupts and empirical research corrupts absolutely. And so I'm wondering, we have different assumptions in these different rules. If we're going to look at a wider range of possible interventions, is there some way we can increase the likelihood of it being done more effectively? So,
You want me to try mine
please.
first? So that's when I was using the activation energy metaphor and pointing to C, in other words, the lower, how low the energy state is. So the question that Jay asked was about, is there any serious equity violation? And my first point is, yes, I mean, we should focus on serious, because I think that every equity violation doesn't necessarily rise to the constitutional level. But the basic idea of judicial review and the basic idea of courts protecting education rights is, if you have a serious violation of education rights, the complexity of the system shouldn't bar the courts from enforcing those education rights. That doesn't mean it's pretty or it's going to work out well, but that's the job that I think we should entrust our courts to. So I wouldn't want to be involved in that litigation, but I think it should take place.
Okay, by the way, I've got to mention that I'm very happy everybody's quoting Peter Schuck. You'll notice that he had a blurb endorsement on the back of my book, so he's supportive also.
That's why Rick read it.
But does he agree with Professor Hanashek?
Well, I don't know where Professor Hanashek ultimately comes out on the value of the things I was saying in that book. Anyhow, on your very interesting question about what we might do to make courts effective, more effective in those areas where they should get involved, or maybe they will get involved. For me, one of the big issues, and one of the reasons that I am speaking in what some may see as a very cautious manner, I know I'm very often tagged by the press, and they're always looking to put people in different slots and all that. I'm assumed to be a judicial activist and always want judges to be intervening in things. And I've gone out of my way to take a very careful position on this, precisely because I think this atmosphere we're in, where there are all these attacks by politicians, and it's not only politicians, it's very thoughtful academics and others, that courts should not be getting involved in these things at all. Once the courts get involved in policy making, they're doing something in violation of separation of powers. They're being unconstitutional. I think that's wrong as a matter of history. I think it's wrong as an interpretation of separation of powers. But that's why when courts get involved, they've got to be very cautious. They've got to do it within a separation of powers framework that limits their involvement both from the judicial resources point of view and from the relationship with the other branches. So what I'm really looking for is exactly what Jay said at the introduction of our panel. Is there a principled way to draw lines when court involvement is both appropriate and can be really helpful? And I guess that's where I disagree with Kevin. I may agree totally with his list of things that we should have better policy directions on, but as far as the court being the one to intervene on those, I can't see the list, to be honest with you, but probably I would limit it to a very small fraction of those.
Okay. Professor Dunn, I have a question for you. You said you were sympathetic to the plaintiffs in Vergara, and I'm wondering, if you believe that the challenged statutes do impede students' rights to an appropriate education or a sound basic education, how do you think those statutes can be changed if political forces in the state are in a position to block substantial modifications in current law?
Okay, well, first I would say that I'm sympathetic to the plight of having ineffective teachers in their classroom. I'm just not convinced that these statutes are really most responsible for that. My suspicion is they are, but I haven't seen the evidence to, and I think there's so many other things that contribute to it that their overall effect is pretty minimal. Now, still, though, California strikes me as a fairly dysfunctional place politically. And so I don't know if I were in California, I might be tempted. So that, I don't know if that answers your question, but and also I would say I'm not certain, I disagree that there is a right to a particular kind of teacher. I think this is it's a problem, but I'm not certain that it's a constitutional problem. I don't find much evidence from the text of the California Constitution that it's a constitutionally protected right. So.
Okay. I mean, Professor Wellner said these are problems, and
Right.
if the responsible branches of government would deal with them, I'd be fine. We wouldn't need to go to the courts. I assume you...
It'd be much
Right.
preferable, yeah.
Sure,
Much
sure.
preferable, right. So in your situation, if you see the right to a teacher as critical, and I think we've all agreed on that, and you think the legislature, because of political gridlock or whatever, is unlikely to do any of the things that would lead us in a better direction, you're still closed to the idea of
Yeah, courts
somebody
can
like
always make
Judge
things
Troy.
worse.
I'm sorry?
Courts can always make things worse by intervening. They can try and fix the problem, and their solutions will make students worse off. So I think that's my primary fear, is that you have unintended consequences that actually degrade the quality of education in California as a result of this. Yeah.
Other branches of government have also done things that had unintended and unfortunate consequences. I have a completely different question, and that is, in a prior panel, we talked about social science evidence in court. And I think, Professor Hanishek, you mentioned a footnote 11 in Brown and said that was lousy research, or, you know. My question is this: aren't there fundamental social science assumptions underlying almost every important judicial decision? I'm going to contrast Brown with its predecessor, Plessy versus Ferguson, in which the Supreme Court, without citing social science evidence of any kind, said, if Negroes think that state-imposed segregation stamps them with a badge of inferiority, it is only because they choose to put that construction upon it. Now, they offer no support for that. I have to think this is based on assumptions about how society is or should be. If judges are operating on the basis of those assumptions, would we rather have them be explicit about them, rather have them invite qualified people to present social science evidence that might help them work that through, or would we rather have them operate on those assumptions without even acknowledging that they're making social science assumptions without much explicit support?
Sure. Well, first I would say that I don't think Brown needed footnote 11 in order to arrive at the conclusion that it arrived at. That's my problem. It was the correct decision, but the reasoning is suspicious, and there's a good book on this, What Brown versus Board of Education Should Have Said. I had several legal scholars rewrite the opinion, and almost no one agreed. I don't think anyone actually agreed with the psychological harm thesis of Brown, that they thought that could have just been decided purely under the Constitution. Now, that being said, yeah, you would obviously prefer to have judges rely on good social science, but there's even outside of court, there's of course disputes about what constitutes good social science, and my concern is that the courts themselves just don't lend the way they process this information and the incentives that are created through the adversarial process. I just disagree with Michael about how well courts do at this. I simply think that there aren't incentives to produce really high-quality social science that they can rely on. The adversarial process creates incentives. Expert witnesses know that the judge isn't trained in their particular area, so they can, and they're going to nevertheless have to present things to the judge in a way that the judge can understand. So that will inevitably they will end up simplifying. You don't even have to assume bad motives and say they're going to mislead. So I simply think that's the problem. Yeah, in an ideal world, it'd be great if judges could just have social scientists come in and give completely reliable testimony about the effects of different remedies. But I'm just doubtful that those circumstances
I'm
occur
just
much.
tempted to make one comment, and then I know we should go to the audience, but it always struck me as being very significant that Professor Gene Glass from the University of Colorado a number of years ago, as well as Professor Levin from Teachers College, both wrote articles that said after they had been involved as witnesses in major litigations that they thought the judicial fact-finding process, its analysis of social science, was much more thorough and much more objective than anything they had experienced in their years in academia. So I'll leave it at that.
Quality in a service, which was different than the questions that was originally posed, which was whether or not there should be a right to quality, effective teachers. That's a quality standard. It's not a comparative one. And in that regard, whether for rightly or wrongly, I think it would be interesting to think about the experience of courts with the one real quality standard. Perhaps Justice Rehnquist said it was a quality standard, not just a process standard, for an appropriate public education in the special education area, where the courts uniformly have been much happier with the procedural ones and have almost written the quality standards out in their reluctance to have to grapple with what is quality in special education. And I think there is a very strong reluctance in the courts themselves to recognize or think that they don't have the capabilities to make decisions in that area. Given, I wonder if you'd be, go back to the original comment about whether you think there is really any life for a quality standard apart from the equality issues, which were raised in California and which really also are a very strong part of that opinion.
So if I'm understanding correctly, let me know if I'm not appropriately responding. But my response was very much focused on equality, and these issues are very much focused on equality. I think that I would have a lot more trouble with turning to the courts for quality determinations. I mean, I think it's just interesting in listening to the questions asked and the responses. It's appropriate to be thinking about the three branches in very different ways. That's how they were set up, to be doing different things. But the level of tolerance that we have for complete dysfunction in the legislative and executive realm versus the level of, if courts might make things worse, then we can't go to the courts, right? I mean, how often do we think that legislatures and executives are, I mean, we all can think of lots of examples where they've made things worse. I mean, I like playing the game of picking apart awful judicial decisions and pointing to poor uses of social science as much as anyone else. I've done it many times. It's shooting fish in a barrel, and there's a real problem with how courts have dealt with social science, but it's not like we haven't come up with critiques of the executive and legislative process too. What are we on, like year 6 of ESEA non-reauthorization? I mean, these are not functional branches. And we need, if we care about these issues, we need to entrust our courts, I think, with a bigger role, even though we know it's going to be problematic as well.
Yes.
Hi. So I would like to answer the question that you have on the main slide for this particular segment, which is, are courts the right place for this type of litigation or this type of movement? And from our perspectives of parents who are plaintiffs on the case, The answer, unfortunately, is yes. The entire purpose of the judicial system is to give a voice to people who don't have a voice. And we don't have the deep pockets as labor unions or other lobbyists do to go to the legislature and say, we want to enact this type of reform. This is our only shot. And even if we take money out of the equation, I bet, Michael, right now, if the dean of Columbia University came to you and said, hey, you know, Michael, we're going to rewrite all of our rules for how we work at Columbia University, and I'd like you to help me, as altruistic as you may be and the teachers' unions may have been, the end result of those rules may be slightly tilted toward the favor of teachers, and there may be some unintended consequences. What we're trying to say as parents is that when these laws were enacted, we were not at that table. We did not have an opportunity to say, if you do this, this is how it may affect us. We now have an opportunity to say, because you have done this, this is how we feel we have been affected, therefore we want this particular type of change. This is the only opportunity that we have. Now, if the court does not feel that they should, venture into this, they will say so, okay? But as a citizen, we have the right to bring this to the judicial system because it's the only avenue we have, and that's the purpose of the system. So I'll throw that question back out to you and say, is it the right place? It's the only place that we have.
Yeah, I really appreciate those comments, because what you're saying is really that the courts do have a very important and rare role in allowing, really one person can go in and raise a huge constitutional issue, and you can be heard. And it's interesting that you say that's a place you can go when you don't have resources, because many people say the need to hire a lawyer and go through 7 months of trial or whatever is a huge obstacle. But we did see today a lot of examples of people, lawyers, being willing to work pro bono, and that's fantastic. And it probably, even with all the detail that goes into a court case, you're probably right that it's less expensive for parents than to mount a huge lobbying campaign, especially in this day and age when part of lobbying seems to be giving huge amounts of money to different politicians to get them to do things. So it's a reason the court should be involved, but my question again is, when should they be involved, and how much can they do of this? And we've got to think very clearly about that.
Ms. Bott?
Thank you, Professor Heubert. This is a synthesis question across the three panels, because it seems that the issue of whether the concept of a quality teaching force and the concept of compensating quality teachers has been more or less the elephant in the room. So we have people here from Colorado, from California, from New York. I'm curious what those of you who consider yourself to be expert in the benchmarking of entry-level compensation believe is the right answer in terms of the percentage increase, if you so believe. The percentage increase from what we now pay entry-level, highly qualified, competent teachers. Where I'm going is, if we want to, in the long run, avoid the issues of incompetent, unqualified teachers or what, if you really believe that there's a different way of recruiting and compensating and incentivizing teachers, what would that number be now? Just to give you some background for those of you who are not in New York. We just raised our teacher salaries, our starting teacher salaries in New York City this past summer to $46,000. With additional training at Teachers College or wherever, you can get $56,000. But that's where we are. Where should it be? That's my question.
Well, you know, one thing I'll say here, because again, Rick Hanyashek and I agreed on a point here. We both signed our names to a report from the National Commission on Equity and Excellence that recommended substantial increases. I don't know if we had exact numbers in there, but we did. You don't remember that, Rick? We recommended substantial increases for teacher salaries.
But the point they add to this is that that's a very improperly formulated question.
tough professor.
Levels of salaries with the structure of salaries, that is all in one.
Let's just start with starting salary for someone with no additional training. That's what you do.
That you're going to keep the single salary schedule and just ride up.
Single salary schedule.
But that's what we agreed on in this report, is that you should have substantially larger salaries if you change the single salary schedule and got away from that to one that had, was tilted more toward the effectiveness of teachers. And so that's what we agreed to.
Well, wait a minute, Rick, I think you may have thought you agreed to that. I don't know that we had all those qualifications. But, you know, I'll just also point out there was a very interesting article in the Times today reporting a study that essentially said the problem is not so much starting salaries or final salaries, it's where teachers are in those middle years. And we've been talking today about problems of retention, that 50% of the teachers in our urban areas drop out before year 5. So that seems to be the area that the fifth year, between the fifth and 10th years, that we need to give a lot more attention to.
Could I just want to add, I'm not going to answer that question, but I want to sort of, in the same way Rick did, sort of redirect it a little bit. I think that it's important to remember the research that Susan Moore-Johnson brought forth in the last panel about the importance of working conditions. That when teachers are surveyed, and this is not just survey research, but it's a lot of other research looking at the issue of what's important to teachers and what retains teachers, salary is important, but working conditions are more important. And so keeping in mind all the issues of, do you have a good collegial environment? Do you have the stable and strong and sensible leadership from the principal? Do you have the resources around the teachers so that at the end of the day, the teacher can leave the job feeling good about what he or she has done? Those are the things that in all of us and all of our jobs care about at the end of the day. And teachers are no different. And if we could increase salaries, but if the teacher at the end of the day goes home thinking, I've been a failure and why am I doing this, he or she is not going to stay in the job.
Okay. We have time for one more question.
Hi.
Hi.
It was interesting to me to hear that all of you agreed on the right to an effective teacher, especially given the range of opinions about how involved the court should be. Because it seems to me something that, I mean, obviously if you establish it as a right, the courts are involved at some level. But it also seems like something that would get very convoluted in implementation as far as school choice, teacher compensation, and a range of other things. So I guess I'm curious to hear how each of you sees the role of the courts in something like that.
Well, I guess everybody's looking at me. I'll talk first. Maybe I always do. This is one of the reasons why I said that I think we, myself included, need to give a lot more thought to this question of a constitutional right to an effective teacher. Everybody agrees teacher is the most important element and it's the most important resource. But in what ways do courts get involved? And, you know, I do start from the perspective I mentioned earlier from that bilingual case that probably what courts can do is say to the state, you have a responsibility to make sure that you maximize the number of effective teachers so that all kids can have an opportunity. Exactly how you do that is a policy issue that you better go out and pay a lot more attention to than you have so far. And whether it means any or all of these things you mentioned and a dozen more that people can think about, in the first instance, I think a court would leave to the legislature, to the executive branch, but hold their feet to the fire and say, you know, we're going to come back in a year, 2 years, whatever it is, see what policies you've come up with, see if you've adequately financed them, see if they're working, and if they're not, then we're going to put more pressure on you. And exactly what form that pressure takes becomes a second level of remedial oversight. But this is tricky, and you know, in the finance area, I said we had manageable standards. And why I'm reluctant to rush into this area is I think we have to think a lot more about what the judicially manageable standards would be in this area. Because as I say, I'm not one that would propose that the courts put a lot of resources, time, and effort into an area unless they really have mechanisms for making a difference.
Sure. I'm not certain that I agree that there is a constitutional right to an effective teacher. It would be nice, but for the very reasons that it's difficult for courts to identify how you would actually protect this right, that's probably why I see such slender evidence for there being a right in the text of the California Constitution. And so if there's not clear textual support, I think there's actually stronger textual support that you're entitled to an equal teacher, someone who has the same ability as everyone else. But that's, I don't think that's actually contained there, but there's better textual evidence for it. So that just goes to my general skepticism that the courts are, if there's not something there from the text that they could build manageable standards off of, that there's actually a right contained in it. And I, of course, would want highly effective teachers in every classroom, but that's the problem with positive rights. They're very difficult to actually protect through the courts, and that's what you have. You're imposing an obligation on the government, a substantive one that maybe the government the courts aren't actually capable of protecting.
I would argue that there might be a right to effective teaching as opposed to effective teachers. I was just looking up here to see whether I put working conditions on my list. and because it would be interesting to think about restructuring the David's case or the Wright case around effective teaching rather than effective teachers. And if you think about it, the working conditions in a school limit the effective teaching in every single classroom, not just the classroom of the grossly ineffective teachers, right? And there's stronger research, as Dr. Johnson pointed out, there's really stronger research in this area about working conditions creating effective teaching. And so I would argue that, that's ultimately what we care about for our kids. And I would argue that that would be a much better way to structure a lawsuit like this, although, all the points that have been raised about how unwieldy this sort of litigation is would still apply.
Professor Hennig has authorized me to bring our conversations to a close. So I want to begin by thanking all the panelists for spectacular, intellectually exciting conversation all day today. Thank you also, Ms. Davids. I also, would like to thank everyone at Teachers College who was involved in the planning of this event. There were quite a few, and we're all grateful. And at this point, I want to declare this moment the beginning of the period of the day reserved for non-learning. Good night.